Hi, my name is Ryan Fowler, and today we're going to talk about charging order protection. First off, what is charging order protection? Well, a charging order is actually a very limited creditor remedy. It's so limited that most creditors don't like it, and it's inadequate, and it actually is a type of protection for any type of partnership or LLCs. And it's one of the main features of LLCs or partnerships that we use, the big reason that we use them for asset protection, basically. Generally, a charging order means a creditor of a partner or member of a partnership or LLC may not become an owner, member, partner of the entity. They may not attach assets or get assets in the company, may not become a manager of the company, may not force assets out of the company. They can only get a charging order. A charging order is the right to receive distributions from the company that the debtor would normally receive. They get it instead of the debtor, but they only get it if and when the distribution is made. Usually, if a distribution becomes subject to a charging order, then there's no distribution made because the creditor would get it instead of the debtor, and then the creditor ends up with nothing. And that's why charging orders creditors really don't like them, because usually they don't get anything if they apply for a charging order. And that's why most creditors do not even attempt to get a charging order against an LLC or partnership interest, since they believe it won't get them anywhere, and a lot of times they're right. By way of example, I work with an attorney. It was Dr. Arnold Goldstein. He wrote my second book with him. His firm handled over 20,000 asset protection clients over a 45-year period. He set up well over 10,000 LLCs, maybe over 15,000. His firm did. Many of his clients had creditor problems, several hundred of them did. But out of all those people that got sued and had all these creditor problems, and all these LLCs were set up, only 3 or 4 entities ever got a charging order against them. It just shows you how unlikely and rare it is for a charging order to even be applied for, because creditors realize it usually doesn't get them anywhere. Although a creditor cannot get assets out of a charging order protected entity, we call those COPs, that's any type of partnership pretty much, or almost any type of partnership or an LLC. Well, neither can you, because if you get the assets out, the creditor's entitled to those assets, supposed to go to him. So it's kind of a stalemate. You can't get assets out unless they went to the creditor, and the creditor can't force a distribution, so he doesn't end up with anything. As long as he holds the charging order, that's how it is. Well, and a COP ideally should be structured so that distributions can be made to other partners or members, but not to the person that has a charging order against them. There's different ways to do this. You can allow, in some cases, unequal distributions, or you can have a master, like a master LLC, and then everyone that owns that, a portion of that LLC puts that interest in their own LLC, and that way all these distributions are made from the master LLC to everyone's individual LLC, and then you just don't distribute from your individual LLC. That's another way to go, so that the LLC can keep on making distributions, but the person has a charging order against them, the creditor doesn't get anything. Again, sometimes you can do unequal distributions, which may also be helpful. Now, other people may also get assets out of the company by just performing services or doing something for the company, and then the company pays them. The services do have to be legitimate, but if you have, say, a limited partner, and there's a partnership, and you have 2 limited partners, and one is a debtor to a creditor, and another is not, well, the one that's not can act as an employee or work for that company and just get paid by the partnership, and he gets his money out that way, for example. But he has to actually really do work. Otherwise, if it's bogus and a judge finds out, then he thinks, okay, these guys are playing around with me, and he will probably get more aggressive with his attempts to help the creditor collect, and that is not a good thing. If the debtor tries to get his assets out in a roundabout way without honoring the charging order, assuming creditor gets a charging order, you might anger a judge. It's not a good idea. So you have to do everything on the up and up. And just, plan so that it's not going to be an issue, and you're not going to have to engage in any shenanigans that might tick off a judge. You can set up your planning so it's not going to be an issue, and you won't have to do anything that'll make a judge angry. So sometimes, you know, and by the way, I want to emphasize, if the creditor doesn't get a charging order against you, which he usually doesn't, then you're scot-free and you don't have to worry. You just make distributions and just make sure the money's not sitting in your personal bank account for a long time so the creditor can grab it once the distribution's made. There are things you can do so a creditor cannot get a charging order. Sometimes the other members or partners will buy the debtor member's interest out before a charging order attaches, and then after the whole creditor situation dries up, then you can buy the interest back. That's a way to go. Sometimes the debtor or the other members or partners buy off the creditor for pennies on the dollar. The creditor gets a charging order, it's a pain for the company. I've seen a lot of times 10 cents, 20 cents, 30 cents on the dollar. You know, let's say the LLC interest is valued at $50,000 and they pay him like $10,000 to make it go away. Well, that's not the best case scenario, but it's still a pretty good outcome that you satisfied a $50,000 claim, or you got your $50,000, your interest value at $50,000. You got it back for 10 grand, you know, or something like that. You can set it up so that no distributions are made to the creditor, but if they get a charging order, or they do what's called a foreclosure of a charging order, or you give them your LLC interest. LLCs, limited partnerships, they're pass-through tax entities, meaning the owners have to pay taxes for the company's profits. If you do this correctly, you can get it so the creditor gets a charging order. Now he has to pay taxes for your share of the interest in the company, and he doesn't get any distribution to pay the taxes with. Now, this isn't automatic like some people claim it is. If you look at Revenue Ruling 77-137, the creditor not only needs a charging order, but he needs sufficient dominion and control over that partnership or LLC interest. You want to give him enough control, but not too control. Enough control so that he now has to pay taxes for that LLC or partnership interest, but not so much control that he can now replace a manager with someone he likes, for example. So you really need to draft the partnership agreement or operating agreement just right, and that's, you know, something that's where the experts come in, and they specialize in that, so that you can lay this little trap for the creditor. Creditors most of the time get blindsided by this. They don't understand tax law, and their attorney's a litigation attorney. He doesn't understand tax law. He doesn't understand that, if he gets a charging order, or he gets, you may even give him the interest in the LLC, and it ends up being a Trojan horse because now it's a trap, and they just don't understand tax law. That's not their specialty, and then all of a sudden they get a tax bill. So it can be a pretty sneaky and pretty effective strategy if it's done right, and that's the big if. You really need to know what you're doing there. There are situations where a creditor may circumvent charging order protection. We can usually reinforce against all these contingencies. In another video I talked about, well, here's how a creditor can pierce your veil. Well, guess what? If we do things a certain way, they're not going to be able to use these avenues of attack against you with veil piercing or circumventing the charging order or whatever. So one thing is, if you're the only owner of an entity, single member LLC, or if all owners are debtors to the same creditor, then a creditor sues the owners and tries to get assets in the company, charging order protection may fail. There's court cases where that's happened. So you need to set up the ownership so that there will always be at least one person that is not a debtor to that creditor. And just make sure if you enter into a personal guarantee, don't have all the members of the LLC or the limited partnership or whatever sign that personal guarantee, which can make them debtors, all debtors, to the same creditor, and then the creditor can get through the charging order protection. The reason there is charging order protection is the law is there because it is unfair for a creditor to take control over an entity or get assets inside an entity, and here are owners of the company, they're not a party to the lawsuit, and now they're harmed because their business is interrupted because there's this other creditor here who sues this one member, and these guys are innocent, and now the entire business is interrupted. That's why there is charging order protection in the first place. So you need to always make sure there's one person that won't be party to the lawsuit. When possible, use a state that lists the charging order as the exclusive and only remedy creditors of the owners can use. Some states don't list the charging order as the exclusive remedy. This became an issue in a recent case called Olmstead versus FTC, Sean Olmstead versus FTC. If you Google it, it'll come up pretty quick. It's a pretty well-known case. There are very few states that say the charging order is exclusive creditor remedy for partnerships, but not for LLCs. This is a case in Florida. And what the court noted in Florida is they said, well, the law says it doesn't say the charging order is exclusive creditor remedy for LLCs, although it does for partnerships. Well, this is an LLC involved here, so we can reverse pierce or just hand the ownership over since there's other remedies available, because the law says doesn't say there's not other remedies available. That's how the court ruled. So if you're in such a state, consider a limited partnership or LLP instead of an LLC if you're looking for that type of asset protection. By the way, we can structure an LLC in Florida so that even if they grab your LLC interest outright, they still cannot become a manager, cannot get assets inside the LLC if it's set up correctly. Even if they have other creditor remedies besides charging order protection, it's still not going to avail them anything. So there is planning you can do. The charging order protection by itself is not the only line of defense if your planner knows what he's doing. If the entity is used improperly, then it can be reverse pierced as well. Now, reverse piercing is where, normal piercing is where someone's suing the business or there's bad business debts and they're trying to go after the assets of the owners for the debts of the business. Reverse piercing is they're going after the owners, trying to get assets in the entity for business debts of the owners. Now, in states that list the charging order as the only creditor remedy, it's very possible reverse piercing will not be available to creditors, but don't 100% count that out. If there's an element of fraud or some type of criminal activity that the person being sued engaged in, they may just try and reverse pierce it anyways. But be aware that reverse piercing is tougher to do than normal piercing. Because, again, if a creditor goes in, gets assets in the company and disrupts the operations of that company, well, that company may already have legitimate creditors of the company that now can't get paid their debts. Or, like I said, there may be other owners that have nothing to do with this lawsuit or the action taken by the creditor that'll be harmed by that. And judges have said several times, we're not going to do that if someone is unfairly harmed. And here's some case law. I'm not going to read what this says out, but here's two court cases, and you notice the one on the bottom quotes several other cases, and they say, hey, reverse piercing, a lot of times we're not going to allow it to happen if there's third parties that will be harmed that are not party to the lawsuit. And that is a very key point of asset protection planning. You always set up your entity so that there's going to be someone that would be harmed if a creditor was able to get assets inside of the entity and make it so this person would never be party to a lawsuit. That almost always will stop a creditor in their tracks. A judge will almost never, it's extremely rare for a judge to allow someone who's not party to the lawsuit to be economically harmed. It's basically unheard of. So we structure our entities that way so there will always be someone harmed. If this person that owns 99% of this company gets sued, that 1% person will always be harmed if a creditor gets assets in there, and that just stops a judge cold in his tracks. Judge, pretty much unheard of that they're going to harm that other person. And so that's today's video, and I hope you found this useful.